Mr. Snyder. Committee will come to order. A quorum being present without objection, the chair is authorized to declare a recess at any time pursuant to Committee Rule 2, House Rule 11, Clause 2. The chairman may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which a recorded vote is ordered. Now recognize the gentleman from Oregon, Mr. Benz, to lead us in the Pledge of Allegiance. Thank the gentleman. Pursuant to notice, I call up H.R. 2601, the National Human Trafficking Hotline Enhancement Act for purpose of a markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 2601.
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentlelady from Florida, Ms. Lee, for an opening statement.
Thank you, Mr. Chairman. Today, I'm proud to speak in support of H.R. 2601, the National Human Trafficking Hotline Enhancement Act. This legislation requires that tips received through the hotline are timely shared with law enforcement agencies, which will help protect victims and combat human trafficking. Since introducing this bill in April, my office has had meetings with stakeholders, congressional offices, the operator of the hotline, and others to help enhance the efficacy of the hotline's process. I'm grateful to have endorsements from the Fraternal Order of Police, the Florida Sheriff's Association, and the American Hotel and Lodging Association who favor this bill. The National Human Trafficking Hotline was established in the Trafficking Victim Protections Act of 2000. The purpose of the hotline is to take tips about potential situations involving sex and labor trafficking and to report information to specialized trafficking task forces, federal authorities, local law enforcement, and service providers throughout the country. The hotline has provided more than 15,000 tips to law enforcement since its inception. Since 2007, an entity called Polaris has been the sole operator of the hotline. Recently, Polaris has shifted its focus away from serving as a tip line and instead decided to act as a resource hub for survivors. This is contrary to congressional intent and agency guidance and undermines law enforcement efforts to combat human trafficking. They should be both a resource for survivors and operating a tip line. On February 27th, a bipartisan group of 36 attorneys general from around the country sent a letter to congressional leadership raising concerns about the hotline operator failing to report tips to law enforcement and failing to provide timely information. These attorney generals asked Congress to take action. My office worked closely with them to draft this legislation, which will ensure that law enforcement is given access to the information that they need. The National Human Trafficking Enhancement Act clarifies that law enforcement agencies must be notified of tips that are communicated to the hotline and that the hotline must serve as a tip line as originally intended. Additionally, I plan on offering an amendment today that makes clear that a survivor who contacts the hotline may remain anonymous should they choose. As a former prosecutor and judge in Florida who spent many years investigating and prosecuting human trafficking cases, I know firsthand how devastating this crime can be to survivors and their families, and also how vital it is that tips from business owners, teachers, and the community, as well as survivors, are timely shared with the men and women of law enforcement who work tirelessly to recover survivors and stop perpetrators. This bipartisan bill enjoys the support of numerous members on the committee on both sides of the aisle. I am proud to be part of a broad coalition of our members, and I ask my colleagues to join me in supporting this crucial piece of legislation.
Gentlelady yields back. The chair now recognizes the ranking member, Mr. Nadler, for an opening statement.
Thank you, Mr. Chairman. H.R. 2601, the National Human Trafficking Hotline Enhancement Act, would require the National Human Trafficking Hotline to provide information received through the hotline to state and local law enforcement. While this legislation may be well-intentioned, it misses the point of the hotline. A little history is instructive. In 2000, Congress passed the Trafficking Victims Protection Act, the first comprehensive law to address human trafficking. The TVPA created grants for the protection and assistance of victims of trafficking. In 2005, the Department of Health and Human Services established a 24/7 national and toll-free trafficking information and referral hotline. In 2007, HHS changed the name of the National Human Trafficking Resource Center and expanded the program to develop and disseminate resources for trafficking victims and anti-trafficking advocates and programs. And in 2015, Congress passed the Justice for Victims of Trafficking Act of 2015, which directed HHS to make grants for, quote, a national communications system to assist victims of severe forms of trafficking in persons in communicating with service providers, close quote. That remains both the mission of the hotline and the law. I lay all this out to show that from the hotline's inception through today, its purpose has been the same: to assist trafficking victims and to connect them with service providers so that they can escape and recover from trafficking. The hotline's purpose, as defined by Congress, has never been to receive tips or to act as an agent for law enforcement. Nonetheless, the hotline does provide information to law enforcement in certain limited circumstances. Law enforcement is informed when a victim requests that the hotline contact law enforcement, when a minor is involved, and when a victim is in imminent danger. These limited circumstances appropriately put the safety of the victims first. There have always been other ways for the public to provide tips to law enforcement about trafficking. The Department of Homeland Security, for example, directs those with trafficking tips to call the Homeland Security Investigations tip line. And notably, it directs victims seeking assistance to the National Human Trafficking Hotline. Consistent with the law, the website explains that the hotline is, quote, not a law enforcement or immigration authority and is operated by a non-governmental organization funded by the federal government, close quote. This distinction could not be clearer, yet this legislation would completely erase it. Survivors of trafficking and advocates for the rights of survivors, many of whom appear to be with us in the hearing room today, have told us that this separation between law enforcement and the hotline is critical to ensuring that the hotline fulfills its mission to assist victims and survivors. On September 1st, the U.S. Advisory Council on Human Trafficking, a council of survivors created to advise the government and strengthen our anti-trafficking efforts, wrote to Congress to oppose this legislation. I ask unanimous consent to insert this letter into the record.
Without objection.
The letter explains that, quote, many victims of trafficking do not report what is happening to them due to fear of law enforcement. Automatically involving law enforcement without survivor consent will disproportionately harm the communities the hotline intends to serve and have a chilling effect on calls made to the hotline by human trafficking victims, end quote. While it may seem counterintuitive, trafficking victims, even those who later cooperate with prosecutors, may not want to immediately report their case to law enforcement. Freedom Network, the largest alliance of human trafficking survivors, service providers, and advocates, also opposes this bill. And I ask unanimous consent to put their statement in opposition to the bill in the record.
Without objection.
Their statement explains that, quote, many survivors are working to avoid law enforcement due to previous harmful interactions, traffickers who threaten retaliation, or the vulnerable immigration status of the survivor or family member. Reporting to law enforcement without explicit consent erodes the trust of survivors and may push them away from the very services they need to leave a trafficking situation, close quote. Freedom Network's statement further notes that hotlines for domestic violence and runaway youth similarly promise confidentiality, enabling them to gain the trust of these vulnerable populations and get them to safety. We should listen to these survivors of trafficking and ensure that the hotline continues to be able to serve as a trusted resource for victims. Victims need to be able to call for help without having to worry about a poorly timed response impeding their escape. Victims need to be connected with service providers without fearing their own prosecution for acts they undertook as a trafficking victim. Once they've escaped, many victims do want to work with law enforcement, and their cooperation significantly strengthens the case against the trafficker. But that cooperation will never happen if victims stop calling the hotline because it stops putting their safety first. We urged Republicans to reconsider this legislation in light of the concerns from victims and survivors, including those who are in the committee room with us today, but they refused. In light of these concerns, I must urge my colleagues to oppose this legislation, and I sincerely hope that we can work together in future efforts that prevent trafficking and serve the needs of survivors, informed by their experience. Before I yield back, I want to note that Ranking Member Jackson Lee regrets that she cannot attend today's markup. As many of us know, human trafficking is a very important issue to her. She has always been able to work on these issues in a bipartisan fashion and hopes that at some point we can do the same with this bill, while centering victims and survivors of human trafficking in the discussion. I also ask unanimous consent to enter To enter into the record, the Protect All Children from a letter from the Protect All Children from Trafficking Network, National Survivor Network, from the Alliance to End Slavery and Trafficking, and from the Rape, Abuse, and Incest National Network that operates the National Sexual Assault Hotline.
Without objection.
In opposition, these are all in opposition to the bill. With that, I yield back.
Without objection, all of the opening statements will be included in the record. The chair now recognizes the gentlelady from Florida for the purpose of offering an amendment in the nature of a substitute.
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 2601.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for the purpose of the amendment. The chair now recognizes the gentlelady from Florida to explain the amendment.
Thank you, Mr. Chairman. This amendment makes clear that information obtained by the tip line from a victim of human trafficking will not be shared unless the victim affirmatively consents to such information being provided to law enforcement. This amendment...
The gentlelady, I think you were offering your amendment. We were talking about the amendment in the nature of a substitute.
Oh, pardon me, sir.
Okay, that's fine. Who now seeks recognition? The gentlelady from Florida is recognized for her.
Did she get the INS? Did she offer the INS?
Yeah, I think ANS has been offered. Without objection, the ANS considered as read, right? We've done that.
Yes, sir.
Now, who seeks recognition? Gentlelady from Florida is recognized because she has an amendment. Yeah, she has an amendment to the amendment in the nature of a substitute. We got it. Gentlelady is recognized to talk about her amendment.
Thank you, Mr. Chairman.
Yeah, we're good.
So the amendment offered would, as previously stated, allow a victim of human trafficking who contacts the tip line to remain anonymous unless that victim specifically consents to their information being provided to law enforcement. This amendment is intended to address the concerns that have been stated by groups about survivors being able to remain anonymous. I would also like to note that on the subject of the purpose of the original hotline, that the Administration for Children and Families in the U.S. Department of Health and Human Services administer this grant, and Polaris is currently the entity contracted to provide it. On their website, ACF describes the purpose of the hotline to, quote, take tips about potential situations involving all forms of sex and labor trafficking and facilitates reporting to specialized human trafficking task forces, federal authorities, local law enforcement, and service providers throughout the country. Moreover, the notice of funding opportunity for the hotline states that one of the 4 project objectives is to notify law enforcement agencies of the potential cases of human trafficking as well as instances when trafficking victim is in imminent danger and document emerging trafficking schemes to assist in the detection and investigation of trafficking cases. Certainly, the intent of this bill is to fight to protect survivors and also to ensure that we stop human trafficking. And it is important to recognize that both must occur. So we absolutely recognize that supporting and providing resources to victims is vital. However, we can't stop traffickers without also working with the men and women of law enforcement who are on the front lines of this issue every day. Without them, the traffickers remain out there to identify and exploit additional victims. So it is a necessary part of combating human trafficking to engage, support, and work with the men and women of law enforcement who can actually stop and apprehend the perpetrators and put an end to this horrific practice. So this amendment is a balance that protects the concern of the groups that have reached out to our office in the survivors being able to maintain their confidentiality while also ensuring that these important tips continue to be provided to law enforcement so that we can actually combat human trafficking. And final note, this is the contract that was engaged in by this NGO. So it is simply not at their discretion to decide to accept taxpayer dollars and then not perform the functions for which it was contracted. And with that, Mr. Chairman, I yield back.
Gentlelady yields back. The chair now recognizes the ranking member, Mr. Nedler.
Thank you, Mr. Chairman. With regret, I must oppose this amendment. The victims have reviewed this amendment. They say it doesn't satisfy their concerns. It still makes, it will still have a chilling effect on survivors calling in to the hotline, and therefore I must oppose the amendment and as well as the bill. I yield back.
Gentleman yields back. Who seeks recognition? The gentleman from Maryland. And we will maybe go one. We have votes and about 10 minutes left in the vote, so maybe Mr. Ivey, and then we'll have to take a recess.
So speak quickly?
Yeah. Well, no, we'll give you your full time, Mr. Ivey, but then we probably have to head to the floor.
Yes, sir. Thank you, Mr. Chairman. And to my colleague, I say I appreciate the effort to do this and, want to continue to our offices to keep working to see if we can find a way to resolve this. I would note just for the record that the gentlelady from Florida floated alternative language last night. We've made an effort to try and see if we can resolve this with some of the groups that the chairman recognized or referenced a moment ago. But there's still some challenges that remain here. And my role as state's attorney in Prince George's County, we had a lot of human trafficking issues. We had a lot of domestic violence issues. And one of the things I did when I first got into office was to push for a mandatory arrest policy with respect to domestic violence calls. And what I quickly learned in getting feedback from victims who had been making those calls was that they did not want me to do that. And the reason was because there were a variety of circumstances where the person making the call just needed help immediately, but might have been concerned about long-term consequences, about if the police showed up at the time. Another issue was people who were trying to develop an escape strategy, hadn't figured it out yet and needed to figure out how to work with people who could help them do that. And part of that's a trust issue too. So I know we all come to this in good faith, and the public servants, the police and law enforcement who want to help with this, the people who answer the hotlines. But when that victim picks up the phone, she doesn't know who's on the other end of it. She doesn't know if she can trust them. She doesn't know what assistance she can get. And so that leads to the need to develop trust over time, and sometimes that gets in the way of people who need to make the calls but aren't sure about the result that will come if there's an automatic report. And so I take the gentlelady at her word. I agree. I want to see if we can find a way to thread the needle on this. But I would note, for the record, a couple articles I'd like to offer. The chairman offered some already, but there's one in the Tampa Bay newspaper, Aubrey Ailes. I hope I'm pronouncing the name correctly. But the article's, "Here's Why a Well-Meaning ID on the Sex Trafficking Hotline Could End Badly." Now, I know the amendment that the gentlelady's offered would help to address some of that, but I would respectfully request that we be given additional time to work with your office and the community who represents on these issues. They got the language that was proposed last night. We were trying to work through that last night. The language that's offered today is slightly different than that. It's got some of the concerns I still had, but I would say we both have the same goals. I would just ask for additional time to work with your office and anybody else that wants to join in on this and see if we can find a common way to get this done, because we all want the same things, and I think we can get there. I yield back.
Gentleman yields back. The committee will take a recess to head to the floor for vote. We will be recessed for, I'm assuming, a half an hour or so, and we will. Votes will be over in half an hour? Well, let's hope so. I think we only got 2 votes, so hopefully we'll be back here. Let's try to be back and rolling by 11 o'clock. With that, the committee stands in recess. Committee will come to order. The chair recognizes himself. What I'd like to do, based on the discussion we had before votes on the floor, is if we can maybe pass Ms. Lee's legislation and then continue to work with our Democrat colleagues to see if we can iron out the concerns. I know Mr. Ivey expressed some support for the amendment Ms. Lee offered to try to fix the concerns that were brought forward, but he felt that wasn't quite enough. So if we could pass Ms. Lee's legislation, I know Ms. Jackson Lee is a co-sponsor of the bill. That's what we'd like to do, is see if we can get this passed and then continue to work with our Democrat colleagues as we before we bring it up on the floor. I would yield time to the gentlelady from Florida for comments that she may have on the amendment and the underlying legislation.
Thank you, Mr. Chairman. I'd first like to ask unanimous consent to enter into the record the February 27th, 2003 letter to leaders in Congress from the National Association of Attorneys General.
Without objection?
Second, I'd like to seek unanimous consent to offer into the record the Administration for Children and Families Office and Trafficking on Persons National Human Trafficking Hotline Program application.
Without objection?
All right. And Mr. Chairman, also I do want to note how much I appreciate the support and interest in this important issue from our colleagues on both sides of the aisle. My office has been working with stakeholders and also other members seeking input about this issue since April, and I am certainly willing to work with our colleagues as we take this bill to the floor to help alleviate any remaining concerns. I particularly want to thank Ranking Member Jackson Lee and the other members who expressed an interest in this issue and a willingness to work alongside with me in co-sponsoring this bill and also addressing and alleviating any ongoing concerns that continue to exist. I know we share a strong commitment to combating human trafficking and exploitation wherever it exists, and stand ready and willing to work both with survivors and also the men and women of law enforcement who are on the front lines of apprehending and putting a stop to human trafficking in communities across our country. And with that, Mr. Chairman, I yield back.
Gentlelady yields back. Who seeks recognition? Question. We need someone to yield to you, Mr. Ivey, I believe, because we're still on the amendment that Ms. Lee offered. The gentlelady from California is recognized.
I move to strike the last word, and I yield to Mr. Ivey.
Mr. Ivey is recognized.
Thank you to my colleague. I do want to thank the gentlelady for offering to continue to work on this. I did want to go ahead and put on the record some of the issues that we see in the language, and so that we can sort of focus on working on those. Just three very quickly. One is the definition of imminent threat. The concern that I've heard and that I share is that it's undefined, and so we're not sure how broad an exception that would be or when it would apply. And the way it could be applied could have a very detrimental effect, a chilling effect, essentially, on people who might call in. Number two, as I understand it, this would create a different level of treatment for this hotline than for other types of hotlines, say like suicide prevention or sexual assault, and where you don't have the same kind of mandatory requirements. And I think we should really think through why we would do that. The logic on the other issues is the same that we discussed, the impact on victims, the chilling effect, and the like. I think we really want to be careful on this issue because human traffic, which frequently does involve issues of sexual assault, and you're going to have a lot of overlapping issues. I don't think we want to have a scenario where a victim in a situation, which call she makes to which hotline determines what type of treatment or assistance she gets. I think we want to make sure that it's uniform and consistent across the board. And then lastly, I would say, in the gentlelady's language that was floated today, the word severe was added as opposed to what was there last night. My understanding is that the goal is to track the legislation, but there were actually some, when I looked up the definition of severe in the existing legislation, it raised additional issues for me as well. So, because it's drawing lines in that definition that I'm not sure makes sense for this particular goal of determining when a mandatory contact would be made. With that, Again, I want to say to the gentlelady, I greatly appreciate her effort to address this concern. I share the goals that she's expressed, and I look forward to working with her to try and address those going forward. And with that, I yield back to the gentlelady and thank her for yielding time.
Gentleman yields back to the gentlelady from California. Gentlelady from California, Ms. Lofgren yields.
I yield back.
The gentlelady yields back. Who seeks recognition? Question occurs on the amendment. Offered to the amendment in the nature of a substitute. All those in favor say aye. Aye. Those opposed? No.
No.
In the opinion of the chair, the ayes have it. The question now occurs on the bill. Who seeks recognition?
Wait,
Amendment in nature of a substitute, excuse me.
could we seek a vote? No? Okay.
Question now occurs on the amendment, the amended amendment in the nature of a substitute. Question occurs on, if no one seeks recognition, the question occurs on that. Those in favor say aye. Aye. Those opposed? No. In the opinion of the chairs, the ayes have it, and the amended amendment in the nature of a substitute is adopted. Question is on the adoption of the amendment in the nature of a substitute. In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute adopted. A reporting quorum being present, the question is now on favorably reporting the bill as amended. All those in favor say aye. Aye. Those opposed, no.
No.
The ayes have it, and the bill is ordered to be reported favorably to the House. To the House, members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Notice I call up H.R. 5430, the Prohibiting Punishment of Acquitted Conduct Act of 2023 for the purpose of a markup, and move that the committee report it favorably to the House. The clerk will report the bill.
HR 5430 to amend section 3661.
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes himself for an opening statement. The right to a trial by jury is a hallmark of the American criminal justice system. The right is so important that the founding fathers enshrined it in the Bill of Rights. Our commitment to trial by jury means that we accept the jury's decision whether we agree with it or not. This legislation would prohibit judges in federal court from increasing a defendant's sentence based on conduct for which the defendant had been acquitted by jury. In 1987, the United States Sentencing Commission established sentencing guidelines to be used by federal judges during sentencing hearings. These guidelines allow judges to consider all relevant conduct in sentencing hearings, explicitly stating that the conduct that is not formally charged or is not an element of the offense of conviction may enter into the determination of the applicable sentencing. In other words, a judge may consider conduct that was not formally charged or proven beyond a reasonable doubt at a trial, so long as the judge finds the conduct relevant by a preponderance of the evidence using information that has, quote, sufficient indicia of reliability. There are numerous examples of this happening. Judges have intervened to overrule the determinations of juries and given defendants harsher sentences by considering conduct for which the defendants had been charged and acquitted. Allowing judges to consider acquitted conduct punishes people for a crime for which they have not been convicted. It is wrong, and it violates the spirit of our Bill of Rights. The late Justice Antonin Scalia urged for the end of this practice, the practice of using acquitted conduct at sentencing. So has Justice Kavanaugh. In 2015, when he was a judge for the U.S. Court of Appeals for the D.C. Circuit, Judge Kavanaugh wrote, quote, allowing judges to rely on acquitted or uncharged conduct to impose higher sentences than they otherwise would impose seems a dubious infringement of the rights to due process and to a jury trial. I agree with both justices. The bipartisan bill before us now, H.R. 5430, the Prohibiting Punishment of Acquitted Conduct Act of 2023, would correct this injustice. Identical legislation was reported out of this committee and passed the House under suspension last Congress under Chairman Nadler. I want to thank our former Judiciary Committee colleague, Representative Armstrong, and our current colleague, Representative Cohen, for introducing this legislation. I urge my colleagues to join me in supporting it. With that, would yield to the ranking member for his statement.
Thank you, Mr. Chairman. H.R. 5430, the Prohibiting Punishment of Acquitted Conduct Act of 2023, is an important measure to end the practice of federal judges increasing sentences based on conduct for which a defendant has been found not guilty by a jury. This bipartisan bill introduced by Representative Kelly Armstrong and committee member Representative Steve Cohen specifically prohibits the consideration of acquitted conduct at sentencing if not for mitigation purposes. In order to convict any defendant of a crime, the Constitution requires that the government prove that defendant's guilt beyond a reasonable doubt. The Sixth Amendment right to a trial by jury and the Fifth Amendment's due process clause require that each element of a crime charged against the defendant be either admitted by the defendant or proven to the jury beyond a reasonable doubt. Despite these foundational guarantees, federal law allows judges, in effect, to override a jury's verdict of not guilty and to sentence defendants for acquitted conduct. Current law bars any limitation on the conduct of a sentencing court may consider for the purpose of imposing punishment, and the, quote, relevant conduct provisions of the U.S. sentencing guidelines allows a sentencing court to consider a range of factors, including acquitted conduct. Based on this guidance, federal judges may enhance sentences if they find, by a preponderance of evidence, a lower evidentiary standard than required at the guilt-innocence phase, that a defendant committed other offenses. Although the Supreme Court has passed on considering this issue to date, the late Justice Scalia provided a scathing critique of the practice in his dissent in Jones versus the United States. Joined by Justices Thomas and Ginsburg, Justice Scalia said that the petitioners presented, quote, a strong case that, but for the judge's finding of fact, their sentences would have been substantively unreasonable. In that case, the court declined to hear a case in which 3 defendants were found guilty of distributing small amounts of crack, but were sentenced as if they were convicted of a much larger conspiracy to distribute drugs for which they were charged, but found not guilty at trial. While the sentencing guidelines recommended penalties ranging from 27 to 71 months for the charge each defendant was convicted of, the defendants were sentenced to 180, 194, and 225 months, punishing them almost 4 times more harshly for conduct the government could not prove at trial. This practice is fundamentally unfair, and as Justice Scalia said, this has gone on long enough. The failure to address this issue for so many years has contributed to the epidemics of over-incarceration and mass incarceration, weakened the finality that a jury trial is meant to provide, and undermined overall public confidence in our justice system. Therefore, today we consider a simple, narrowly tailored bill that builds on our bipartisan efforts to create a fairer justice system. This legislation amends current law to preclude judges from considering acquitted conduct, except for the purpose of mitigating a sentence. The bill will make sure that defendants are punished only for the conduct that prosecutors are able to prove at trial, consistent with the constitutional guarantees of due process and the right to a trial by a jury of their peers, and consistent with the principles on which this country was founded. A broad coalition of advocates supports this significant but modest legislation, including R Street Institute, the ACLU, the Innocence Project, the Brennan Center for Justice, the American Bar Association, Families Against Mandatory Minimums, the Leadership Conference on Civil and Human Rights, and federal public and community defenders. We passed this legislation out of committee in the last Congress by voice vote, and it passed the House under suspension by a vote of 405 to 12. I hope the Senate will join us this year and will send this important legislation to the President. I thank our colleague Steve Cohen for his commitment to justice and the Constitution and for leading this effort alongside Representative Kelly Armstrong. I urge all of my colleagues to support this bipartisan legislation as we have in the past, and I yield back the balance of my time.
Gentleman yields back. The chair now recognizes the gentleman from Tennessee, Mr. Cohen.
Thank you, Mr. Chair, and I do appreciate your putting this bill on the calendar as well as my other bill on the calendar. You have well explained the reasons for passage, as has the ranking member. I'm not going to go through all of those points again, but I would like to emphasize Kelly Armstrong was a strong supporter and an excellent co-sponsor, and I appreciate him. And Senator Durbin and Grassley are on the Senate side as sponsors. Just about every Supreme Court justice that has been around lately, from John Paul Stevens and Anthony Kennedy to Anton Scalia, who's been mentioned in a joint dissenting opinion with Justice Ruth Bader Ginsburg and Clarence Thomas, and then going down to Gorsuch and Kavanaugh, have all said this needs to be changed. So with that, I would ask that we move forward and arrive at justice. People should be convicted of proven crimes and sentenced for those crimes. That's why we need the bill, and make sure that people are only sentenced for the crimes they are convicted of. With that, I yield back the balance of my time and ask for a positive vote.
Gentleman yields back. Who seeks recognition? Gentleman from Maryland, Mr. Ivey.
Thank you, Mr. Chairman. I can't pass up the opportunity to say that I agree with the chairman in his opening statement,
God bless.
and Justice Scalia.
God bless.
It's a rare day. But I've been an attorney who's been on both sides of these cases, and I share the view that this is a true injustice, truly undermines the jury system, and I appreciate Congressman Cohen for your efforts in leading this, and I certainly join in support of this amendment. I yield back.
Gentleman yields back. Any other member seeking recognition? Reporting quorum being present, the question is on favorably reporting the bill. All those in favor say aye. Aye. Those opposed, no.
Mr. Chairman, ask for a recorded vote.
Gentleman from California asked for a recorded vote. The clerk will call the roll.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Isa? Mr. Buck? Mr. Isa? Mr. Buck? Mr. Gates? Mr. Biggs? Mr. McClintock? Mr. McClintock votes aye. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Bishop? Ms. Sparts? Ms. Sparts votes yes. Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Bentz? Mr. Klein? Mr. Gooden? Mr. Gooden votes aye. Mr. Van Drew? Mr. Van Drew votes yes. Mr. Nels? Mr. Moore? Mr. Kiley? Mr. Kiley votes aye. Ms. Hageman? Ms. Hageman votes aye. Mr. Moran? Ms. Lee? Ms. Lee votes aye. Mr. Hunt? Mr. Fry? Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia? Mr. Johnson of Georgia votes aye. Mr. Schiff? Mr. Swallow? Mr. Liu? Ms. Jayapal? Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Mr. Nagoose? Ms. McBath? Ms. McBath votes aye. Ms. Dean? Ms. Escobar? Ms. Ross? Ms. Ross votes aye. Ms. Bush? Mr. Ivy? Mr. Ivy votes aye. Ms. Ballant? Ms. Ballant votes aye. Mr. Schiff, you are not recorded. Mr. Schiff votes aye. Mr. Gates, you're not recorded. Mr. Gates votes aye.
We got to wait a little bit for some close vote. I think we got to have a few more to get.
Mr. Isa? Mr. Isa votes yes.
Clerk will call.
Mr. Swalwell, you're not recorded. Mr. Swalwell votes aye.
Are we, how about Russ, Mr.
Mr. Massey, you're not recorded. Yay. Mr. Massey votes yay.
Clerk will report.
Mr. Chairman, there are 23 ayes and 0 noes.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, staff is authorized to make technical and conforming changes. Pursuant to notice, I call up H.R. 5404, the Countering Chinese Espionage Reporting Act, for purposes of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 5404, to direct the Attorney General to prepare a
Without
report.
objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from Wisconsin, Mr. Fitzgerald, for an opening statement.
Thank you, Mr. Chairman. In 2015, the Chinese government announced its Made in China 2025 initiative, a strategic whole-of-government plan to supplant U.S. technology superiority. The Made in China 2025 plan calls for a combination of state-sponsored investments in critical and emerging technologies, such as aerospace, information technology, and biomedicine, as well as Chinese government-backed acquisition of foreign companies and their technologies. This initiative has led to a surge in American IP theft by companies and individuals controlled by the Chinese Communist Party, the CCP, which the bipartisan Huntsman Commission on the theft of American intellectual property estimates has cost the U.S. economy as much as $600 billion annually. In 2018, the Department of Justice launched the Chinese Initiative, the China Initiative, which aimed to align DOJ and the FBI efforts with state and local law enforcement to better identify and prosecute those engaged in trade secret theft and economic espionage. The success of the China Initiative cannot be overstated. Federal prosecutors indicted over 162 individuals and entities as part of the initiative, with 45 of those being convicted at trial or in a guilty plea. Despite its success, in February of 2022, the administration did choose to end the China Initiative. This decision raises serious concerns about the DOJ and the FBI's commitment to confront the national security threat posed by the Chinese Communist Party. This bill, the Countering Chinese Espionage Reporting Act, ensures the Biden administration is still prioritizing China's persuasive theft of American IP despite its canceling of the initiative. The bill specifically requires the AG to issue an annual report describing the actions taken by the Department of Justice to counter the Chinese espionage and trade secret theft in the United States, as well as the resources dedicated to combating the national security threats posed by China. Countering the Chinese Communist Party and safeguarding American intellectual property should be a bipartisan priority, and the Attorney General should be eager to provide this report if the DOJ's posture towards China remains unchanged. We have a couple of amendments that I think will also add towards that bipartisan effort. I want to thank the chairman for moving this important legislation, and I urge my colleagues to vote yes on H.R. 5404, and I yield back.
Gentleman yields back. The chair now recognizes the ranking member, Mr. Nader, for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, the operative language in H.R. 5404, the Countering Chinese Espionage Act, is a good idea, prefaced by an unnecessary and misguided set of non-binding findings that, among other flaws, lauds the supposed virtues of the China Initiative. This failed program was ostensibly designed to counter efforts by the Chinese government to steal American intellectual property, but ultimately the program had few results except creating a persistent climate of fear among many Asian Americans. I proudly opposed the China Initiative throughout its short existence. When the program was first put into place by the Trump administration over 5 years ago, I opposed it. When DOJ prosecutors acting under the China Initiative brought flimsy cases against respected academics, I opposed it. And when the China Initiative was used to fan the flames of xenophobia after the outbreak of COVID-19 in early 2020, I opposed it. I was glad to see the program ended in early 2022 by the Biden administration. Mr. Fitzgerald and I disagree on the efficacy and the policy of the China Initiative, but we both believe that it would be helpful for Congress to understand the activities and resources deployed by DOJ to counter the real national security threat from China. And if DOJ is implementing a China Initiative under another name, Congress deserves to know that too. Executive agencies, no matter if they are under a Republican or a Democratic administration, need to share data that can help Congress conduct meaningful oversight. That is why I support the bill's reporting requirement. Unfortunately, this legislation also contains a set of findings that, in addition to gratuitous partisan attacks, harken back to a time when the federal government targeted foreign professors on American campuses, embarrassing the United States and doing virtually nothing to actually counter economic espionage by the Chinese government. For nearly 4 years, the DOJ's National Security Division brought a series of unsupportable cases against Chinese academics at the height of their careers. The government was forced to drop many of these cases. Others failed in court. More were overturned on appeal. Looking back, it seems that the only significant impact of the China Initiative was to make foreign researchers feel unwelcome in the United States. Countries around the world send their best and brightest to the United States for education and to perform valuable research in our academic institutions. But instead of welcoming their contributions to our economy and to our society, programs like the China Initiative encourage them to take their training and their talents elsewhere. In a September 2022 report by the Asian American Scholars Forum, researchers found that between December 2021 and March 2022, 42% of the over 1,300 faculty members surveyed nationwide reported being fearful of conducting research in the U.S. A further 61% felt pressured to leave the U.S., and 45% intended to avoid federal grant applications. I appreciate that my colleagues have been circumspect when talking about the national security threat posed by China, but it is imperative that we differentiate the many people who live and work in the United States from the threat posed by the government of China. As I noted earlier, the reporting requirement contained in this legislation would help further our oversight work. But there is no reason that this helpful provision, which we can all agree on, should be combined with non-binding findings that only serve to divide us. Therefore, I appreciate that Mr. Fitzgerald plans to offer an amendment to strike the findings section, and I intend to support the bill once he does so. I thank my colleague across the aisle for working with us on a bipartisan basis, and I yield back the balance of my time.
The gentleman yields back. The chair advises that all members' opening statement will be placed in the record in its entirety. The chair now recognizes the gentleman from Wisconsin for the purpose of offering an amendment in the nature of a substitute.
Chairman, I do have an amendment at the desk.
Clerk will report.
Amendment in the nature of a substitute to H.R. 5404 offered by Mr. Fitzgerald of Wisconsin.
Without objections, the amendment will be considered as read, and the gentleman from Wisconsin is recognized to explain his amendment.
Chairman, the First Amendment is very simple. It just makes a short title change in Section 1 of the bill from Countering Chinese Espionage Reporting Act to Countering Chinese Espionage Reporting Act of 2023. I urge its adoption.
Okay. Seeing no one seeking the gentleman from Wisconsin is recognized for a second amendment.
Mr. Chairman, the Second Amendment I have at the desk, as mentioned.
The clerk will report.
Amendment to the amendment in the nature of a substitute to H.R. 5404 offered by Mr. Fitzgerald.
Without objection, it'll be considered as read, and the gentleman is again recognized.
Yeah, Mr. Chairman, as I mentioned and the ranking member had alluded to, this amendment removes the Section 2 from the bill, which makes 18 findings related to China's theft of intellectual property, as well as the administration's response to China initiative. This amendment is no way, it doesn't alter the reporting requirements of the bill and is meant as a gesture to the minority. However, I did want to make clear that I stand by all the findings in the bill, which have been supported by overwhelming evidence, as was made clear over multiple hearings in the subcommittee. And I hope that I hope this helps colleagues on the other side of the aisle join us in supporting this very important piece of legislation. I yield back.
The gentleman yields back. The gentleman from New York is recognized.
Thank you, Mr. Chairman. Mr. Chairman, I'd like to thank Mr. Fitzgerald for his bipartisan work on this amendment. We disagree about the China initiative, that much is clear. But we both understand that China poses a national security threat and undermines American intellectual property both at home and abroad. By removing the bill's findings, we are left with a useful provision to mandate that the DOJ report to Congress every year for 7 years on its efforts related to countering national security and espionage threats from China. Ideally, we will be better able to track the important work DOJ does to keep us safe. And if the DOJ takes steps to reinstitute the China initiative in practice, if not in name, then we will know about that too. Either way, this bill provides the opportunity for meaningful oversight over DOJ activities with respect to China. If this amendment passes, I intend to support the underlying bill. I thank Mr. Fitzgerald for working across the aisle with us, and I urge adoption of the amendment, and I yield back the balance of my time.
Gentleman yields back. I want to explain the question now occurs on the amendment to the amendment in the form of a substitute. If that passes, we will then be able to go to the underlying amendment in the nature of a substitute. So again, the question now occurs on the amendment offered by the gentleman from Wisconsin to the amendment in the nature of a substitute. All those in favor say aye. 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 Any opposed, no. In the opinion of the chair, the ayes have it. The ayes have it. The amendment to the amendment in nature of a substitute is agreed to. Does anyone seek further recognition on the bill? Seeing none, the question is on the adoption of amendment in the nature of a substitute as amended. This will be followed by an immediate vote reporting the bill. Those in favor of the amendment in the nature of a substitute say aye. 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 Any opposed, no. In the opinion of the chair, the ayes have it. The ayes have it, and the amendment in the nature of a substitute is adopted. A reporting quorum being present, the question now is on favor of reporting the bill as amended. All those in favor say aye. 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 Any opposed, no. In the opinion of the chair?
Mr. Chairman, I'd request the yeas and nays.
A roll call vote is requested. The clerk will call the roll.
Mr. Jordan? Mr. Issa?
Aye.
Mr. Issa votes aye. Mr. Buck? Mr. Gates? Mr. Gates votes aye. Mr. Biggs? Mr. McClintock? Mr. McClintock votes aye. Mr. Tiffany? Mr. Massey? Mr. Massey votes aye. Mr. Roy? Mr. Bishop? Ms. Spartz? Ms. Spartz votes yes. Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Bentz? Mr. Klein? Mr. Klein votes aye. Mr. Gooden? Mr. Gooden votes aye. Mr. Van Drew? Mr. Van Drew votes yes. Mr. Nels? Mr. Moore? Mr. Kiley? Mr. Kiley votes aye. Ms. Hageman? Mr. Moran? Ms. Lee? Ms. Lee votes aye. Mr. Hunt? Mr. Fry? Mr. Fry votes aye. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson-Lee? Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia? Mr. Johnson of Georgia votes aye. Mr. Schiff? Mr. Schiff votes aye. Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Mr. Neguse? Ms. McBath? Ms. McBath votes aye. Ms. Dean? Ms. Dean votes aye. Ms. Escobar? Ms. Ross? Ms. Ross votes aye. Ms. Bush? Mr. Ivy? Mr. Ivy votes aye. Ms. Ballant? Ms. Ballant votes aye. Mr. Biggs? Mr. Biggs votes aye.
Does anyone else seek recognition that hasn't voted? The clerk will report.
Mr. Chairman, there are 24 ayes and 0 noes.
The ayes have it. The bill is ordered to be reported favorably to the House. Members will have 2 days to submit their views. Without objection, the bill will be reported as a single amendment in the nature of substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 3315, the National Guard and Reservists Debt Relief Extension Act of 2023 for purposes of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 3315, to exempt for an additional 4-year period.
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from Virginia, Mr. Klein, for an opening statement.
Thank you, Mr. Chairman. I want to thank the gentleman from Tennessee for working on this bill. Under existing law, certain National Guard members and armed service reservists are presumed to meet the means test in the bankruptcy code. The means test helps bankruptcy courts decide if a debtor is eligible for bankruptcy forgiveness under Chapter 7 of the bankruptcy code. The test assesses recent income and expense data to gauge a consumer's ability to repay their debts. However, the means test would be a challenging obstacle to debt forgiveness for National Guard members and armed services reservists, since the income and expenses of those reservists and members can change dramatically when transitioning from civilian life to active duty and back again. The means test does not adequately account for these changes in income and expenses, and this bill responds to that concern by extending for another 4 years the existing means test exemption or presumption for certain qualifying National Guard members and armed service reservists. Current means test exemption is set to expire in December. Congress has extended the policy several times in the past. The men and women in our National Guard and Armed Services Reserves protect our country and put their careers on hold when called to active duty. The bill makes sure military personnel are not penalized in bankruptcy court after serving our country. I urge my colleagues to support the bill, and I yield back.
The chair now recognizes the ranking member, Mr. Nadler, for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, according to a 2022 lifestyle survey of service members and veterans, financial issues were the top lifestyle stressor, and unfortunately, bankruptcy is sometimes the best answer for those in financial distress. Under current law, National Guard members and reservists who serve on active duty are, like other active service members, exempt from the Bankruptcy Code's means test, which determines whether a debtor's income is too high to have all of his or her debts erased in bankruptcy. But this critical protection for National Guard members and reservists must be extended before it expires at the end of the year. Unless otherwise exempted, service members and veterans must complete the required forms and submit the specified paperwork to satisfy the Bankruptcy Code's means test. This burdensome requirement applies even with respect to service members who have returned to the United States from active service and thus no longer receive combat pay. Under the means test, such service member must calculate his or her income based on the average monthly income that he or she received during the 6-month period preceding the filing date of the bankruptcy case, rather than the debtor's actual income, which may be much less because of the debtor's non-combat status. Without this exemption, some service members and veterans may be prevented from seeking the financial relief that they need and deserve. H.R. 3315, the National Guard and Reservists Debt Relief Extension Act of 2023, responds to this immediate concern. The bill would extend for 4 years the temporary authorization exempting certain qualifying reserve component members of the armed services and National Guard members from the Bankruptcy Code's means test. If we do not act, this critical protection for service members and veterans will expire in a matter of weeks. I hope we can act on a bipartisan basis, as we have before, to extend this authority without delay. I commend the bill's sponsor, the gentleman from Tennessee, Mr. Cohen, as well as his co-sponsors, the gentlewoman from Pennsylvania, Ms. Dean, the gentleman from Virginia, Mr. Klein, and the gentleman from Tennessee, Mr. Burchett, for their deep commitment to supporting our nation's heroes. Accordingly, I encourage my colleagues on both sides of the aisle to pass H.R. 3315, and I yield back the balance of my time.
The gentleman yields back without objection. All other opening statements will be included in the record. Who else seeks recognition? Oh, the gentleman from Tennessee, Mr. Cohen.
Thank you, Mr. Chair. I'll be quite brief. I've had this bill since 2008. It's an appropriate manner of dealing with the bankruptcy courts and the folks that serve us as reservists and the difficulties they might have in meeting their debts when they're sent overseas in particular. Oftentimes, payday lenders hang around military installations and get soldiers to sign payday loans because they're sometimes in stress. They're even more stressed when they're not, they're overseas and acting as guard members and away from the original business where they were earning employment. So this relief is justified. It's been on the books since 2008. It needs to continue, and I particularly appreciate Mr. Klein, Ms. Dean, and Mr. Burchett, not Burchett, but Burchett, for their co-sponsorship. I yield back the balance of my time.
The gentleman yields back. Does anyone else seek recognition? Oh, Ms. Dean.
Thank you, Mr. Chairman. I will be brief. I move to strike the last word.
Gentlelady is recognized.
I rise in support of H.R. 3315, the National Guard and Reservist Debt Relief Extension Act of 2023. As some of my colleagues have already explained, this bill extends authorization to exempt certain U.S. military service members from having to satisfy the means test under the Bankruptcy Code. According to the National Foundation for Credit Counseling, more than 1 in 5 military service members are unable to pay their monthly bills outside of housing, loan, and credit card payments. The demands of active service, moving frequently, being deployed overseas, often make it difficult to maintain financial security. Financial stressors also weigh heavily on our veterans. These Americans have put their lives on the line to defend our country. They had our backs. We must have theirs. I'm proud to be an original co-sponsor of this bipartisan bill. I thank Mr. Cohen for faithfully bringing it forward. I urge my colleagues to join all of us in support of H.R. 3315. I yield back.
Gentleman yields back. The gentleman from California, Mr. Carrera, is recognized.
Thank you, Mr. Chairman. I concur with the comments made by my colleagues. We owe a tremendous debt of gratitude to our service members, and to think about the situations that find themselves in financially. Let's face it, we don't pay them enough for what they do. I'm going to support this bill, but I would just ask Mr. Klein, Ms. Dean, and Ms. Burchett to consider making this exemption permanent. We've extended this over and over again, and it's time we just make it a permanent one. So I ask the authors to consider making it permanent in the future. Thank you.
Gentleman yields back. Would the gentleman yield to the, Mr. Carrera, would you yield to the gentleman from Tennessee?
Certainly consider it, and I'll talk to Mr. Burchett personally.
Now the gentleman yields back. Anyone else seek recognition? A reporting quorum being present, the question now occurs on reporting favorable the bill, reporting the bill. All those in favor say aye.
Aye.
Any opposed? Hearing none, the ayes have it. I was going to get to that. The ayes have it, and the bill is reported favorably to the House. A recording vote being mentioned, or ordered. The clerk will call the roll.
Mr. Jordan. Mr. Issa.
Aye.
Mr. Issa votes aye. Mr. Buck. Mr. Gates. Mr. Gates votes aye. Mr. Biggs. Mr. Biggs votes aye. Mr. McClintock. Mr. McClintock votes aye. Mr. Tiffany. Mr. Massey. Mr. Massey votes aye. Mr. Roy. Mr. Bishop. Ms. Sparts. Ms. Sparts votes yes. Mr. Fitzgerald. Mr. Fitzgerald votes aye. Mr. Bentz. Mr. Klein. Mr. Klein votes aye. Mr. Gooden. Mr. Gooden votes aye. Mr. Van Drew. Mr. Nels. Mr. Moore. Mr. Kiley. Mr. Kiley votes aye. Ms. Hageman. Mr. Moran. Ms. Lee. Ms. Lee votes aye. Mr. Hunt. Mr. Fry. Mr. Fry votes aye. Mr. Nadler. Mr. Nadler votes aye. Ms. Lofgren. Ms. Jackson Lee. Mr. Cohen. Mr. Cohen votes aye. Mr. Johnson of Georgia. Mr. Johnson of Georgia votes aye. Mr. Schiff. Mr. Schiff votes aye. Mr. Swalwell. Mr. Swalwell votes aye. Mr. Liu. Ms. Jayapal. Mr. Correa. Mr. Correa votes aye. Ms. Scanlon. Mr. Neguse. Mr. Neguse votes aye. Ms. McBath. Ms. Dean. Ms. Dean votes aye. Ms. Escobar. Ms. Ross. Ms. Ross votes aye. Ms. Bush. Mr. Ivy. Mr. Ivy votes aye. Ms. Ballant. Ms. Ballant votes aye. Ms. McBath, you're not recorded. Ms. McBath votes aye.
The clerk will report.
Mr. Chairman, there are 24 ayes and 0 noes.
The ayes have it. The bill is reported favorably to the House. All members will have 2 days to submit views. Without objection, staff is authorized to make technical and conforming changes. Ladies and gentlemen, this concludes the committee's business. This meeting is adjourned.